Okay. What do you think? Should we begin? Okay. Professor Snead, I think we'll go ahead and get started then, right? And let people jump on as they can. Well, good evening, friends, and welcome to the first ever Zoom lecture sponsored by the St. Thomas More Society of the Diocese of Wilmington and the Notre Dame Alumni Club. We've been collaborating together for the last dozen years or so and have brought some really great speakers in, including at least one U.S. Supreme Court justice. But our speaker tonight, I think, is equally stellar. One of my heroes, St. Augustine, once said, "The truth is like a lion. You don't have to defend it. Let it loose. It will defend itself." If so, our speaker tonight has let loose a literary lion in his work, What It Means to Be Human, The Case for the Body in Public Bioethics, which is named by the Wall Street Journal as one of the 10 best books of 2020. As he explains, his book is a proposal made in friendship and solidarity and intended to be received in that spirit. It's a proposal for a more wise, just, humane, and fully human public bioethics. It begins, as he will explain, by remembering the body. Our speaker, Carter Snead, is professor of law at Notre Dame Law School, concurrent professor of political science, and director of Notre Dame's De Nicola Center for Ethics and Culture. He's one of the world's leading experts on public bioethics, the governance of science, medicine, biotechnology, in the name of ethical goods. His research explores issues relating to human embryo research, assisted reproduction, abortion, and end-of-life decision-making. In addition to his scholarship and teaching, Professor Snead has provided advice on the legal and public policy dimensions of bioethical questions to officials in all three branches of the U.S. government and around the world. Prior to joining the law faculty at Notre Dame, he served as general counsel to the President's Council on Bioethics, chaired by Dr. Leon Kass, and led the U.S. government delegation to the United Nations Educational, Scientific, and Cultural Organization, UNESCO, where he served as its chief negotiator for the Universal Declaration on Bioethics and Human Rights. In 2016, he was appointed to the Pontifical Academy for Life, the principal bioethics advisory body to Pope Francis. Just a few program notes before we begin. We will have time for Q&A. If you have a question, please send it through the chat box, and I'll relay it to Professor Snead when we get to that portion of the evening. If you're a Delaware lawyer and you're looking for CLE credit, please email me your bar number, and we'll make sure you get a certificate of attendance. If you'd like a copy of Professor Snead's PowerPoint presentation, we'll post that on our website, as well as a recording of tonight's talk in case you have friends who would like to hear the talk but weren't able to make it tonight. So thank you all for joining us, and I'll hand it over to you, Professor Snead. Thank you for joining us.
Thank you so much, Matt, for inviting me to the Thomas More Society, as well as to the Notre Dame Club in Delaware. As I was telling Matt before we began, Delaware is special to me. It's kind of an adopted home state. My mother-in-law and father-in-law live in Lewis, Delaware, down on the coast there, and we're there all the time. We'll be, in fact, driving there from South Bend, Indiana, not in the not too distant future, a couple times this summer, there and back. So those of you who've made that drive, it's a long drive, but it's well worth it to go to Delaware. So, and I'd like to thank all of you who are joining us this evening for my talk. I know it's everybody's busy, and it means a lot to me that you all decided to tune in this evening. So thank you very much for that. I'm going to share my screen with you so that I can use my PowerPoint, which Matt said also he can make available to you after the lecture, if that is helpful, if that's something that you're interested in. So let's see here. Matt, can everybody see my screen to get the PowerPoint going? Okay, great. So the title of the talk is taken again from the book. It's the same title as the book title. And what I'd like to do this evening is to frame for you some of the principal claims of the book and the arguments. We can just share those with you. And then we can talk about applications of the argument in the question period if we have time and if you guys are interested. But the book basically makes two claims, one of which is a methodological claim and the other is a substantive claim. The methodological claim is that the richest and most potent method of analyzing matters of public bioethics is through what I describe as an inductive anthropological inquiry. And that sounds highfalutin and maybe obscure, but it's really not. All it means is it asks you to take the law as you find it, or the public policy as you find it, and then ask the question of what vision of human identity and human flourishing anchors and animates the law and policy that you're analyzing. What vision of the person and human flourishing does the law assume? And I'll explain in a moment why I think that's an especially useful way to analyze legal and policy questions, and especially useful in the context of American public bioethics. Substantively, what I argue in the book is when you take that mode of analysis, when you analyze inductively this anthropological question, and I mean anthropology here, and I'll say more about this in a moment. What I mean by anthropology is very literal and original, not its modern sense as an academic discipline, but rather simply the question of what it means to be and thrive as a human being. And when you ask that question of the so-called vital conflicts of American public bioethics, the legal disputes over abortion, assisted reproduction, and end-of-life decision-making, what comes to the surface is a vision of human identity and flourishing that anchors the law that has been described by certain philosophers and social scientists as expressive individualism. And there are certain things that are true in the account of expressive individualism about who we are and what we owe to each other. But as I argue in the book, it's not a full account of who we are in all of our complexity. And it's a vision at the end of the day that can't and won't make sense of the lived reality of human embodiment and everything that comes along with it, including our vulnerability, our reciprocal dependence upon one another, and our subjection to natural limits. And because expressive individualism doesn't give us a full and complex, comprehensive picture of what it means to be human, it shouldn't serve as the grounding good or grounding vision of human personhood that animates these areas of the law, or really any areas of the law, and not a fit foundation for public bioethics. Okay. The framework to help unpack these substantive claims and explain what I mean more clearly is as follows. First of all, I'm going to define for you what I mean when I say public bioethics. I'm going to talk a little bit about the history of American public bioethics, what it means as an area of law and public policy. I'll enlarge upon what I said a moment ago about the proposed anthropological analysis of law and policy as a general method. I will spend some time talking about what I mean by expressive individualism. And I'll explain why I believe that it's an incomplete conception of the self. That is, to use Alistair McIntyre's words, a famous Catholic philosopher who's at Notre Dame even now. He's retired, but he is permanently in residence at the Nicholas Center for Ethics and Culture, where I work. His office is next to mine. I think he's about 93, 94 years old. And he's still today one of the most important, arguably the most important living Catholic philosopher. To use his phrase, that expressive individualism is forgetful of the body. I mean, it doesn't take on board our bodies and our embodiment as an essential aspect of our identity. And then I'll argue that what's needed to augment this incomplete vision of the human person and human identity and human flourishing as a grounds for law and policy is what I describe as an anthropological corrective. What's needed is that we remember the body, that we take seriously our embodiment as an essential feature of who we are, and then to unpack what it means for how we stand in relation to one another, what we owe to each other, and also discuss what are the goods, practices, and virtues that are necessary to build up what's required for our shared and individual embodied lives together. Now, I know the framework says that I'll then turn to the question of the public bioethics of assisted reproduction, but I think I'll probably stop at the previous bullet point and open the floor for questions and conversation, so we don't eat up all that time. If you want to talk about how I apply this analysis to the concrete areas of that I take up in the book, abortion, assisted reproduction, end-of-life decision-making, I'm happy to do that during the question period. So let's start then with the question of public bioethics, what it is, what it means, what its definition is, what the scope of it is. Put very simply and directly, public bioethics is the governance of science, medicine, and biotechnology in the name of ethical goods, as distinguished from bioethics just as an intellectual field of inquiry, right? Bioethics is an intellectual field of inquiry, simply the discourse, the scholarship, the conversations that we all have about the ethical issues that arise from advances in biomedical science and biotechnology. But public bioethics is the governance of these areas of human activity. And it is where the government, whether it be in the form of the political branches, the legislative branches, or the executive branches, whether that be at the state or federal level, or the administrative agency level, which of course is part of the executive branch, or even at the judicial level, the point at which governance, in which the government comes in and takes a position on these particularly contested matters of bioethics, either by encouraging and endorsing certain kinds of practices through, for example, the use of federal funding, or on the other end of the spectrum, forbidding and prohibiting or even punishing certain kinds of practices. And then there's a lot of real estate between affirmative governmental endorsement and government prohibition. There is neutrality and silence, allowing for private ordering. There is licensure and certification. There is bans with exceptions. There's data surveillance and record keeping. There's a whole wide array of government and very fine-grained array of government activity in the area of public bioethics. It isn't simply saying a binary yes or no. There's those of you who are lawyers in the audience know that there's a lot the law can do, including simply by being silent and allowing for private ordering. That too is a form of governance. And that's really what I'm talking about, is the governance of science, medicine, and biotechnology in the name of ethical goods. And this area of law and policy, and it is an area of law and policy, is fundamentally concerned with human vulnerability, dependence, frailty, and finitude. It's about procreation and pregnancy and babies and wasting illnesses and devastating injuries, desperate enrollees in clinical trials, fearful patients, the disabled, the elderly, the dying, and the dead. Put another way, public bioethics is most deeply about the meaning and consequences of human embodiment, the fact that we experience ourselves, one another, and the world around us in, and more importantly, as living and dying bodies. Now, American public bioethics emerged in the late 1960s and early 1970s as a field of American law and public policy. There were three signal events that I focus on in the book that illustrate, I think, the paradigm of this particular form of governance, but it also illustrates substantively the kinds of solutions that we frequently gravitate towards in this area that relate to, and for that matter, the kinds of scandals that provoke government reactions. Public bioethics has historically been a kind of reactive form of governance. There's usually the cycle usually is there's a scandal, there's a government reaction, and then the government reaction takes the form usually of hearings, and then passage of some kind of, if we're talking about the political branches of government, passage of some kind of legislation, which might leave some space in the language of that legislation that gets filled in by an administrative agency or the executive branch of the government. And usually, substantively, the solution that we are attracted to in American law and policy is to try to protect individuals and to promote their flourishing through the vindication of the principle of autonomy and self-determination. That's the thing that we're most drawn to. Although, for reasons that I'll explain, that while it's an important good and something that we should always take into account, is not, in many cases, the solution that's needed to protect a particular vulnerable population, because usually in many cases these populations are vulnerable precisely because they can't exercise their autonomy, exercise their self-determination as many of us are able to. So there are three signal moments in American public bioethics at the very beginning, at its inception, that sets in place a kind of paradigm, both procedurally and substantively, for how we react to these kinds of questions. On your screen, you see three images. The first image of the one solitary gentleman with the white coat, that's Henry Beecher. He was a famous anesthesiologist at Harvard Medical School and a student of the ethics and practice of human subjects research. And in 1966, in the New England Journal of Medicine, he published an article that detailed 22 experiments performed. They were anonymized in the publication, but it later came to light that these were experiments that took place that were performed by some of the highest and most esteemed people and institutions in America and in the world. The US government, Ivy League schools, universities, different research entities that had the esteem of the elite community as well as the broader community. And in these 22 experiments, there were instances that they all were characterized by examples of exploitation and abuse and mistreatment of vulnerable populations who were serving as human subjects, research involving human subjects. So research experiments, and the people that were being experimented on were exploited and abused and treated terribly. And only they were engaged in human subjects research that did not offer any therapeutic benefit at all for the human subjects involved. And in every single case except for 2, there was not even an attempt to secure informed consent. But in most of the cases, informed consent wasn't even a possibility. And to take 2 of the most sort of heinous examples, the intellectually disabled children at the Willowbrook School on Staten Island were deliberately injected with hepatitis and infected with hepatitis for the sake of a research protocol that secured that advised the parents broadly about what was happening, but at no point did they actually talk about the risks involved with the children. And so it was a grave breach of informed consent, but worse than that, it was the deliberate injection of hepatitis into children with intellectual disabilities. In another example, detailed by Dr. Beecher, there was a case involving the injection of live cancer cells into patients suffering from age-related dementias at the New York Jewish Chronic Disease Hospital. And these are 2 egregious examples, but they're generally reflective of what went on in the cases that are described by Dr. Beecher. The second image that you see in the middle of your screen is from Macon County, Alabama, a place called Tuskegee, Alabama, in which the United States government, over a period of more than 40 years, systematically deceived and exploited the poor African-American sharecropper community, whose community had the highest incidence of syphilis of any community, any county in the United States. And so U.S. researchers, not U.S. funded researchers, but literal employees of the federal government went into Tuskegee, Alabama, and deceived this poor community about what they were doing. What they were doing was to observe the natural progress of the disease of syphilis throughout this population without treatment. And so they didn't offer any treatment to these people. They didn't tell them what they were doing. They didn't tell them where they could get treatment or that treatment was available. And then about several years into the study, they when penicillin became standard of care for alleviating the symptoms and treating syphilis, none of the people were advised of this possibility. And there's even some reports that there was collusion between the American government researchers and the local health authorities to prevent these people from finding out any of this information. This went on for decades and decades, from 40 years, and came to light in the 1970s, around the same time as Beecher in the early 1970s, and of course created a massive scandal that resulted in a $10 million civil settlement for the victims. But not before the disease ravaged these families, and its transmission went through this community without any assistance or effort to help, or even truth-telling on the part of the federal government researchers. And of course, they rationalized it by saying, well, this was a very poor community, and these folks probably wouldn't have gotten treatment anyway, so we didn't make their situation worse than it already would have been. That was what they attempted to argue. That, of course, was not accepted as a plausible justification for the deplorable behavior of the American researchers, the federal government researchers in this case. The last image you see on your screen there is the image of a child in utero, and that represents a third scandal that occurred roughly contemporaneously with the Tuskegee scandal and the scandals flagged by Dr. Beecher. There were American researchers who would travel to Scandinavia and would coordinate with abortion providers. And what they would do, and in Scandinavia at the time, abortions were performed by hysterotomy, meaning that it was basically the babies that would be delivered by C-section and then just allowed to expire, rather than the methods of abortion that were more common in the United States at the time. And what these researchers realized is that these ex utero, that is post-delivery unborn children, not unborn anymore, but actually born, newborns, who had just been aborted and who were imminently dying by virtue of the intention of the abortion itself, would be valuable research subjects because these were living newborns that were imminently dying, but could be used as research subjects. And these scientists did a wide variety of research subjects, which extended the lives of these newly born, of these neonates that had just been aborted but were imminently dying, that caused their demise. That in many cases it was reported caused and enhanced the pain that these newborns and neonates suffered. And this similarly was published in the Washington Post in April of 1973 and sent shockwaves through the American community. And in fact, Eunice Shriver, the sister of Senator Ted Kennedy and the late John F. Kennedy and the late Robert F. Kennedy, Eunice Shriver, married to Sergeant Shriver, the founder of the Peace Corps and the Special Olympics, were so scandalized by this that she approached her brother to see if he would convene hearings to study these questions. And their daughter, Maria Shriver, who was, of course, a journalist who was later married to the governor of California, Arnold Schwarzenegger, organized a protest at the NIH at her Catholic high school to protest the funding of this kind of research. So what happens next is Ted Kennedy convenes hearings studying all these questions, not merely the questions relating to abortion and neonates that had so troubled his sister, but also the questions of Tuskegee, the question of that were surfaced by Dr. Beecher, as well as a wide variety of other questions, public bioethical questions. And these hearings culminated in the passage of a statute called the National Research Act, which did a variety of things. It created the National Commission on Bioethics, the very first one, that was later superseded and replaced by presidential level commissions, which is the kind of commission that I served as general counsel for the President's Council on Bioethics under Leon Cass. But it also put in place certain kinds of moratoria on research involving newly aborted neonates or newborns, or research on living fetal human beings in utero, until pending a report from the National Commission on Bioethics making recommendations. And also it put in place the foundation for what later became the principal human subjects protections in federal law that applied to the federal government and to agencies within the federal government. So the unique features of American public bioethics, as is evident from this kind of brief historical sketch, is that, first of all, American public bioethics is extremely complicated and complex. It involves the seamless integration of great goods with the possibility of serious and grave risks. Every single person involved in all of these cases, every single researcher involved was not intending to do something wicked or evil or harmful. They all were intending to do something positive and beneficial, and every single thing that they did plausibly produced generalizable knowledge that was useful, but the means that they chose to pursue this generalizable knowledge were unethical. The bioethical American public bioethics is also contested. It's concerned with very sensitive questions concerning the nature, meaning, and consequences of birth and life and death and procreation and parenthood and childhood and race and poverty and illness and scientific freedom and autonomy and dignity and equality and justice. And it squarely presents the question of who are we and what do we owe to one another. And these are matters about which people strongly disagree and sometimes bitterly disagree. And this is a unique feature of American public bioethics. American public bioethics involves what I describe as vital conflicts, zero-sum matters of life and death, the contours and boundaries of the moral and legal community, who counts as one of us, whose good counts as part of the common good. And as you probably surmised from my discussion of those examples, a lot of times we seek refuge in autonomy as the grounding good for law and policy. A lot of folks argued that the solution to the abuses flagged by Beecher and in Tuskegee and in Scandinavia would be simply to increase opportunities and enforce the requirements of informed consent. But as we saw, informed consent is not helpful to folks who are not capable of exercising their consent because of, well, whether or not they are intellectually disabled children or beset by poverty and systemic racism, as the folks in Tuskegee, or for that matter, newly born babies that had just been aborted who were imminently dying but still alive. Informed consent doesn't make sense as a category when applied to these vulnerable populations. Now, the issues in public bioethics are quite broad. They include, as I've already said, protections for human subject research, embryo and fetal research. What I take up in the book is assisted reproduction, abortion, and end-of-life decision-making. But there's a wide variety of questions that are touched and concerned by American public bioethics. So, why do I argue then in the book that that anthropology, in the way that I'm using it, is a useful way into analyzing these questions and understanding what's at stake and crafting ultimate solutions? First of all, it's important, and the lawyers among us, I think, probably already know this, that law itself is irreducibly normative. Law reflects the goods that people hold dear, that reflects and the harms that they seek to avoid. If you want to understand something important about a particular community, a particular state, a particular country, you can start with what is criminalized, what is endorsed and funded, what is left to private ordering. These give you important insights into what a particular people, a particular polity care about, or aspire to, or afraid of. So law reflects the goods that people hold dear. Now, Oliver Wendell Holmes is not someone that I normally cite for bioethical wisdom, but he was right, of course, when he said that law is the witness and external deposit of our moral life. You can unpack in the law principles of justice and equality and autonomy that a particular people, a particular polity hold and aspire to. But law doesn't merely reflect what a given community believes. It also shapes, for better or worse, public attitudes about these goods and harms, about principles of justice, about what we should care about, what we should be afraid of. Louis Brandeis, after a fashion, said that law is the omnipresent teacher. And again, I say for better or worse because there are a lot more important sources of moral formation than merely the law. But it is the case that the law does have an impact on how people see the world. And again, this is not to say because law is irreducibly normative and you can't do law without principles of justice, without principles of autonomy and equality and freedom and a pretty, at least a pretty operative set of goods and practices and harms that you're considering and prioritizing or seeking to avoid. Just because that's true doesn't mean that everything that's bad should be criminalized or everything that's good should be funded. It's simply to say that everything that the law touches reflects the kind of normative judgment that produced that legal circumstance. But even more deeply still, it's important to understand that anthropology is important for understanding the law because all law exists for the protection and flourishing of persons. That's what law is for. Law is for the protection and flourishing of persons, and therefore it unavoidably rests upon usually undeclared conceptions of human identity. If the law exists to protect people, to promote their flourishing, the law has to have an operating definition of what a person is and an operating definition of what human flourishing is. And what I propose in the book is if you want to understand law most richly and deeply, you drill down to that level, that anthropological level, and you ask the question of what vision of human identity and human flourishing anchors and animates this particular law. Who and what does the law assume persons to be? And then the question that you have to ask is the vision of the law of the human person and human flourishing true? And if it's not true, then it's going to produce forms of protection and forms of promoting flourishing that are not successful. If the law gets wrong who and what we are and what we owe to each other, the mechanisms of the law to protect us and to promote our flourishing are also going to be wrong. And that, it seems to me, is the problem with the vital conflicts of public bioethics that I take up in the book. There's a mismatch between what the law assumes about people and what our flourishing is and the lived reality. And the principal source of this mismatch is the fact that the law fails to take into account the meaning and consequences of our embodiment, the fact that we are the dynamic union of mind and body. We're not mere wills. We're not mere bundles of desires. And for that matter, we're not mere animalistic bodies with which don't have any cognitive reality. We're a mix of the two, okay? And so what is this vision of human personhood and human flourishing that I think is wrong, or at least incomplete in a way to be an unfit to be wrong? And it is, as I said at the beginning, it is the anthropology of what I call expressive individualism. And that's a phrase that was coined by a social scientist named Robert Bellah. who produced a really interesting book called Habits of the Heart in the 1980s, about sort of an empirical analysis of what people think who people think they are and what their flourishing is. And other philosophers have taken up this concept of expressive individualism. Charles Taylor, a philosopher at McGill University in Montreal, in particular, Alistair McIntyre, although he means something slightly different than what I mean when I say it, have used this nomenclature. And I won't get into, I do in the book, the sort of intellectual genealogy of expressive individualism. And it's actually really interesting because it has roots not just in sort of political theory and philosophy, but also has roots in the Romantic literary movement, in which poets and authors sort of made this kind of turn in response to the philosophy of Jean-Jacques Rousseau to develop this self-understanding that I'm describing as expressive individualism, which evolved then and became adopted by the more general population and became kind of ingrained, and especially in American culture, in the 1960s and 70s. So what is expressive individualism? It conceives of the person fundamentally as an isolated, unencumbered, atomized individual self. The fundamental reality, the fundamental human reality, is that of the individual, abstracted from relationships. There are no constitutive relationships. It's a kind of unencumbered self, abstracted from family relations, abstracted from tradition, abstracted from your community, abstracted from any attachments that you might have. The fundamental reality is the individual, the sole individual. That's the individuated, atomized self. And this self is defined by the will, by the desire that he or she has, by one's cognitive capacity to generate endogenously, by looking inside to the original and authentic truths that we find inside ourselves, to discern what our truths are and to configure our life plans generated from the inside. And everything else besides the will and the mind and one's bundle of desires and one's capacity for this kind of introspection and interrogating the sentiments that we have inside, everything else is instrumental. The body is instrumental. It's accidental. It's not constitutive of who we are or what we are. It's merely instrumental and to be used and harnessed to pursue those projects of the will that we generate from inside ourselves, which are unique and original and authentic and have no relationship to anything outside of ourselves, whether it be tradition or family or civilization, what have you. The person is defined instead as an individual chooser or consumer, and human flourishing is defined precisely in this way. It's the pursuit of these projects of your own construction. It's the imperative to live your own originality. In the words of Michael Sandel, you are the self-originating source of valid claims. It is a theory of the person that is profoundly, to use a philosophical phrase, anti-teleological. And all that means is that, so teleology is the idea that there are purposes and ends in nature that are discernible. You can understand what a thing is and what it's supposed to be by virtue of making some kinds of observations about how it its structure, its function, how it behaves, and so forth. And it was a kind of principle of biology from classical antiquity up until some time in more recent modernity, in which this concept of teleology has been abandoned. It's most commonly associated with Aristotle. But expressive individualism is anti-teleological, meaning it believes that there are no external givens that are normative. There's nothing that I can observe in the natural structure and function of things, whether it be myself or a tree or a community or the planet, that gives me a sense of what this thing is. There's no sense of purpose. The only thing that's definitive is the unique and original inner voice that comes from inside each one of us, and that is original and authentic, and everything else is a creative act of bending and shaping the external world, including our own body, to advance our own internally produced goals. Within the framework of expressive individualism, there's no such thing as an unchosen obligation or constitutive attachment. All that matters are the truths that come from inside me. No one has a claim on me unless I choose to allow them to have a claim on me. There's no one who can ask for my aid or who can expect my aid absent a prior judgment on my part and consent on my part to rendering that aid. And similarly, I can't ask anybody for anything absent a kind of transactional encounter where they agree to do so. And personal relationships are instrumental and transactional in this way. And it's not just any personal relationship, it includes the relationship of family as well. Those relationships are transactional and oriented towards the human flourishing as defined by pursuing the projects of my will. And persons as individuated wills encounter each other sometimes as collaborators, but frequently as adversaries, clad in the armor of their rights, to borrow a phrase from Carl Schneider, philosopher, legal scholar from the University of Michigan. The world of ethical goods are within this framework reduced to the concept of autonomy as the highest good. Injustice is the constraint on freedom to pursue the projects of one's own choosing. The role of government and social life is reducible to removing those constraints, public constraints, private constraints, perhaps natural constraints, and otherwise provide the conditions for the assertion of the unencumbered individual self. Now, that's in a very short summary, what expressive individualism is. Why is it problematic? Well, it's problematic because it doesn't, and it can't make sense of our lived embodied reality. The vision of the expressive individual is a will, a cognitive being that is capable of generating one's own future plans and pursuing those own future plans, right? Now, and against all odds, and harnessing ourselves and the world around us and relationships in pursuit of those authentic truths that come from the inside of ourselves. Now, that's a kind of romantic vision. That's a kind of, especially for Americans who admire rugged individualism. But if you think for a second about the arc of human life and the different phases of our lives and how we relate to each other, it becomes very clear that that's not a picture of the human being that captures the full reality and arc of life. Hopefully, and God willing, we all reach a point at our apex of functioning and flourishing that we can, come up with these visions from inside of ourselves and pursue our these goods as we see fit. But there's more to life than that, and that doesn't capture at all the reality of being a vulnerable baby or a sick person or a cognitively impaired person or a person who is in decline, suffering from aging or senile dementia, all of which are artifacts of our embodiment. Because we're embodied, we're mutually dependent, we're vulnerable, we have natural limits. And as Alistair McIntyre says, everybody exists on a scale of disability. At the very best case scenario, we begin life as 100% dependent for our survival on other people. We gradually grow in our strength and powers and become more and more independent. And then we hit a kind of peak. And then we, God willing, begin a gradual decline into total dependence again. But the vision of expressive individualism gets rid of all of those sides of the arc and only focuses at the top of it and assumes that's what a person is. And it can't make sense of our own vulnerability, our own frailty, and it definitely can't make sense of the human dependence that other people have. And it doesn't recognize claims or unchosen obligations that people have on us. It doesn't recall the debts that we owe to others for caring for us. It's intolerant of imperfection. And it misses entirely that what we need as embodied beings are what McIntyre calls networks of uncalculated giving and graceful receiving. The idea that to live, to survive, and then to flourish, and then to learn to become the thing that we're meant to be, we have to be participants in this network of uncalculated giving and graceful receiving, the pristine paradigm of which is parenthood. You come into life utterly dependent upon your parents. Your parents don't take care of you because they have a contract to take care of you. They don't take care of you because you are the realization of some dream that they have about themselves. They take care of you because they're your parent and you're their child, and that's what that relationship means. A child doesn't have to earn the right to be cared for by his parents. A parent doesn't have to be have some external source of obligation to care for his or her children. And so it's these networks that we depend upon for our survival, but they're also networks that teach us to be the kind of thing that we're supposed to become. And as I argue in the book, what we're supposed to become, and this is a normative argument, is the kind of people who can take care of other people without seeking anything in return. The kind of people who can make the goods of others our own good without seeking anything back from it. And to put it sort of more sharply, I argue in the book that by virtue of our embodiment, we are made for love and friendship. And a vision of expressive individualism that only focuses on us at the height of our powers, our cognitive powers, our capacity to formulate and impose our will on the universe, doesn't capture the full truth about who we are. It captures something about who we are, about our free will and our particularity, but it doesn't come close to capturing the realities and the entailments of our embodiment. So expressive individualism, when it becomes a grounding in the law, leads us to be unable to recognize the unchosen claims of the weak, including children, the disabled, and the elderly. It leads to loneliness and dislocation and alienation because we don't understand how to make constitutive relationships. It's death haunted because if you're the center of the universe, your death represents the extinction of the entire universe, all but a stroke, in the words of Alexander Solzhenitsyn. And it erodes social and family ties, which Robert Bellah verified with his empirical research. So what do we do? How do we fix this problem? How do we come up with a vision of human identity and human flourishing that is true to our lived experience as embodied beings, and helps us to build and shore up these networks of uncalculated giving and graceful receiving that we all depend on for our, first of all, for our survival and then for our flourishing? What I argue in the book is that you have to remember the body, and you have to cultivate your moral imagination to remember your vulnerability and dependence, and also to anticipate and see in the future your future dependence, so that you can see in the other their similarly situated circumstance of being vulnerable and mutually and reciprocally dependent on you. And so to do this, to build these up, what I argue in the book, building on MacIntyre, is the practice of what he calls the virtues of acknowledged dependence. And as I've said, the first set of virtues are the virtues of uncalculated giving. And that includes just generosity, giving to people in proportion to their need, hospitality, welcoming the stranger and the other because they are the other and the stranger, not because of something that you hope to get out of it, and misericordia, which is a Latin word meaning the accompaniment of others in their suffering, right? If to help heal and to ameliorate someone's suffering, but sometimes if you can't do that, merely to be with them, to accompany them in their suffering, as Pope Francis talks about. And then the flip side of the goods and the virtues of uncalculated giving are the goods of graceful receiving. Chief among them is the virtue of gratitude, to cultivate and to remember that we owe our current lives to the beneficence of others who made our good their good, who put our goods in front of their goods, as we parents know that that's the model of parenthood that we all aspire to, putting the child's goods in front of your own, sacrificing your own interests for the benefit of your children or your neighbor for that matter. And you remember in gratitude that those did that to you, for you rather, and it should engender this sense of gratitude and motivate you to do the same for others, to care for others in precisely the same way. And also reflecting on one's own vulnerability and embodied nature should lead to a kind of sense of humility, to the realization that everything we have is a gift, that we didn't earn much of what we have, and that and that gifts are distributed unequally in the human community, and that we should extend our hand to those who don't have the same kinds of gifts that we do, and to help them and to support them, to be open to the unbidden, to be tolerant of imperfection, to feel a sense of solidarity to others, especially the weak and the vulnerable, to recognize the intrinsic equal dignity of everyone as embodied beings living in community, to practice truthfulness and honesty. And all of this, I think, can be framed under the aegis, these virtues under the aegis of authentic human friendship. And what we do to cultivate these virtues is to focus on practices that take us outside of ourselves, that draw our gaze up from inside out to looking for others. And as I said throughout this talk, the paradigm is parenthood. As Bella points out, there are also communities of memory, voluntary associations, churches, organizations that are oriented around a good that is outside our own individual self-interest. And so I'm going to stop there because that's the kind of analysis, that's the method, that's the substance, and I won't get into the application of that form of analysis to these particular concrete areas of law and policy. But of course, I'm happy to discuss them in the time that we have remaining. So Matt, I will turn it over to you, and you can moderate the questions, and we can take it from there. I'm gonna have to ask you to unmute. There you go.
Yeah. Okay. Thank you. Can you hear me, Carter?
I can hear you perfectly. Thank you, Matt.
Yeah. One question I had in enjoying your book so much is a lot of those virtues that you speak of gratitude and of caring for the other. You know, the law just seems so every man for themselves, and so, contractually oriented that I wonder how, is it too optimistic to think that we can really inculcate or really promote these virtues that are, beyond the selfishness and self-interest that characterizes most of us, including myself. And so when I read out that list of virtues that we're called to inculcate, it's aspirational, but I just wonder, how do you can't legislate that, so how do you promote that in the law and the way we think about adopting laws?
Yeah, no, that's a great question. And the beautiful thing about American law and how fine-grained it is, it does allow for the possibility of facilitating and promoting certain kinds of private ordering, right? I mean, there are groups like the Little Sisters of the Poor or the Sisters of Life or certain kinds of voluntary associations that practice these virtues and that can be supported and advanced to try to care for those and to try to promote at all levels. And as Catholics, we believe in the sort of concept of subsidiarity, that this should be done at the closest and smallest sort of level of distance from the people that you're seeking to serve. And so there, again, the book doesn't take any sort of make any concrete proposals as far as legislation or statutory whatever. But when you're talking about the political branches of government, you have a lot more leeway for crafting statutes and regulations and so on that are meant to promote certain kinds of behaviors, to create incentives and so forth. But also, the book is importantly points out that there are moments in which, and again, this is a kind of way of seeing, right? Like framing these questions. So to take the example of assisted reproduction, assisted reproduction, the purpose of assisted reproduction, I argue in the book, or any kind of medicine to help people who are seeking to conceive children and to become parents, is to, at the end of the day, have a child who is welcome and loved as a gift unconditionally. Leon Cass calls a child a mysterious stranger that should be welcomed and loved unconditionally. And that purpose, the idea of a child obviously implies a kind of parental relationship, and that sort of notion of parenthood and children should animate how we, so first of all, frame the question that is presented to us, but then also how do we regulate these practices in a way to promote that good and also to avoid the harms that can happen. And in the book, I talk about how we have sex selection as a common practice in IVF. You have batches of embryos that are in freezers and that can be bought or sold according to certain kinds of non-medical traits. There's 1 million embryos in living human embryos in cryo storage. That there's a whole array of exploitation among gestational surrogates and commodification of the body and its parts and all kinds of pathologies that we see because the law in this particular area is completely laissez-faire. There's absolutely nothing to prevent any of these things. And so, as I say, the optimal arrangement is for private ordering to do the heavy lifting and promoting these goods and avoiding these harms. But when that's not possible or when it doesn't happen, you have to intervene. The law has to intervene to protect these weak and vulnerable folks. And so, I think that's the kind of long-winded answer to the question that you ask. Of course, you can't legislate that people practice virtues. You can't legislate that people be friends with each other. But what you can do is try to create incentives and circumstances and to privilege those kinds of practices and support those practices and discourage those practices that are not conducive to people engaging in those kinds of goods and practices that I talk about in the book.
Thank you. I did have one question from Joe Owens, who's the editor of our local diocesan paper. So he's a true journalist. And he asked, the U.S. Supreme Court agreed to hear a case involving a Mississippi law that would ban most abortions after 15 weeks. We'll hear a lot about the current makeup of the court, and the pro-life movement is well known to most of us. I'd like to know, Joe asks, if you can tell some of us lay people what is the strongest legal argument in supporting this law,
Yeah.
What will win the case for those who fight the fight against abortion?
Yeah, great question. Topical question. Tomorrow, I have an op-ed coming out in Newsweek, which is online now. But I hope you guys can check that out tomorrow morning. Matt, I'll send you a link to it tomorrow, which lays out in a very short period, 750 words, what I think the sort of right way to think about this is. And in chapter 3 of my book, I go through in kind of exacting detail the history of American abortion jurisprudence and explaining the issues, and in particular, what's at stake in this case. So the question is, as you say, I mean, the Supreme Court granted certiorari on one question, that is whether or not it is constitutional to have any ban on abortion prior to viability. Roe v. Wade was decided in 1973. It was largely superseded by a case in 1992 called Planned Parenthood versus Casey. And the rule right now that is in the United States is that the Supreme Court is the arbiter of abortion policy in the United States because it claims, I think not persuasively, that the 14th Amendment due process clause, which says no person shall be deprived of life, liberty, or property without due process of law, implies a right to abortion. Now, the due process clause of the 14th Amendment was ratified in 1868 for the purpose of remedying the shameful and disgraceful injustices of chattel slavery after the Civil War, to try to provide fair process and equal protection of law to the folks who had been shamefully denied that in our history up to that point. And no one in America at any level thought that the 14th Amendment meant that the states couldn't protect unborn children with the law. In fact, everywhere in the United States in 1868, the law forbade abortion because it was, in the words of the Ohio legislature, for example, child murder. Okay, so it's a stretch, to put it charitably, to say that the 14th Amendment means the procedural protection of 14th means that you can have a right to abortion. And in American law, and I describe why in the book, the U.S. Supreme Court has said that prior to viability, there can be no undue burdens on abortion. Obviously, a ban would be an undue burden. After viability, the states can regulate abortion if they wish, but they must always include an exception for the life of the mother, which all the laws prior to 1973 had anyway, or the health of the mother, which problematically was defined in 1973 in a case called Doe v. Bolton as any aspect of a woman's well-being, and not just physical, not even just psychological, but also familial and economic well-being, that the abortion provider himself cites as a justification for getting the abortion. And the consequence is that in the United States of America, through 9 months of pregnancy, you can have an abortion by operation of the Supreme Court's interpretation of the 14th Amendment and its understanding of what health means in the contours of the health exception. It makes us among the most extreme countries in the world in terms of permissive abortion laws. And as the Washington Post said in its fact check several years ago, we are only one of 7 countries that allows abortion after 20 weeks of gestation. We, of course, allow abortion throughout every stage of gestation, but there's only 6 other countries in the world that allow it up to past 20 weeks. Okay. So what the court is going to have to grapple with very directly is the question of whether or not Planned Parenthood versus Casey means what it says, namely, is it really unconstitutional for the state of Mississippi to ban abortions prior to viability at 15 weeks, measured from the last menstrual period, I think is how they measured in that case. The court, unless they're going to say the Mississippi law is unconstitutional, they're going to have to modify and arguably strike down and reverse Planned Parenthood versus Casey, and by extension Roe v. Wade. And the strongest argument for doing that is A, that there is no warrant in the Constitution's text, history, or tradition that supports the proposition that there is a right to abortion in the 14th Amendment, and B, principles of stare decisis do not require us to maintain this wrongly decided precedent, because the standard it announced has been proven to be unworkable. It's changed from 73 to 92 to the present. It has been hollowed out doctrinally. The court shifted its rationale from privacy to liberty from 73 to 92 and abandoned the trimester framework in favor of this bifurcated pre versus post viability framework. And most importantly, there's no evidence that women have built their lives in reliance on access to abortion. And even if they have, which that hasn't been demonstrated empirically, The error of Roe for the rule of law, for our politics, and for the 62 million babies that have died in abortions is so serious that it has to be undone. And in my op-ed tomorrow, I explain how on the very same day that cert was granted in Dobbs, 65 years before, the U.S. Supreme Court decided a case called Brown versus Board of Education, in which they said, we're going to overrule Plessy versus Ferguson, which was even older than Roe v. Wade, 58 years. It had maintained the injustice of separate but equal segregation, and entire education systems were based on this error. That's reliance, and the court had the courage to say, we're not gonna continue this error in perpetuity. And most likely what will happen after that, if that happens, is that the matter of abortion will be returned to the states for political resolution. And some states will have very permissive abortion laws, and some states will have very restrictive abortion laws. And the political battle will continue, as it does in Europe and Latin America and Asia and elsewhere, where most governments settle these questions through the normal political process.
Okay, thank you.
Yep.
Here's a question. It's a little opaque to me, but maybe you'll understand it better than I do. Has medicine outpaced the law of ethics? If so, how do we make up the ground? You mean it's just medicine and technology have just gotten so far ahead of the law, I guess, that
I think that is that's a very, the question is a question that you hear a lot, right? They say that our science and technology, our capacity to do things scientifically, biomedically, biotechnologically, has so vastly exceeded our moral and ethical reflection. How do we harmonize those things? And it's a great question. A perfect example is gene editing, right? We now have the capacity to remove segments of DNA and to splice in other segments for various purposes, including creating genetic changes that are heritable, that will be present in successive generations of the same organism. And this raises all kinds of complicated, difficult questions, but we have the ability to do it, and we haven't quite had the kind of conversations that one would hope that we would have in advance of that. And I think that the answer is that we should resist the temptation to do things simply because we can, and we should, as a self-governing people, and we shouldn't cede these questions or the authority to answer these questions to one particular community or another. We have to decide these questions together, and everyone has standing to weigh in on these human questions. I would argue that that we should be very active and engaged as soon as we learn of these things, and even in advance of that. And when we hear about speculative possibilities like artificial wombs or womb transplants, to start the conversations now about about how we think about these things and how we should govern ourselves. And there are examples. These are old human questions, the questions of how to use power, the questions of human dignity, the questions of freedom and autonomy and equality, and what it means to be human, what we owe to each other. We have a tradition to draw upon, and I think that that's the best we can do under the circumstances.
Okay. Here's a question that sounds like it comes from a lawyer. Is it possible to say that the 14th Amendment has been wrongly applied in both business cases and social issues cases? Should not the 14th Amendment be only limited to laws regarding slavery? By that, I mean something like Loving versus Virginia, which prevented interracial marriages, which I think the 14th Amendment was written to prevent. So I'm not sure where that, I guess the initial question was, should not the 14th Amendment be only limited to laws regarding slavery?
Yeah, so I think that it depends on what you think is the best way to interpret the Constitution. And I think for my part, I believe that the way of interpreting the Constitution is most faithful to what the Constitution is and what a judge is to understand, is to try to interpret the words in light of their original meaning, in light of that is to say, how they were originally understood by everyone, not merely the drafters of the words, but everyone at the time, and to try to apply those to be faithful to that original meaning. And the 14th Amendment is a very complicated subject matter. It has a lot of moving parts. It's not just the due process clause, it's also the equal protection clause. It's if Section 5, which has to do with the enforcement authority of the Congress, then it would require a lot more thought and reflection and study of the history and tradition and language and precedents that are associated with that to answer that question directly. But I do think that there are cases in which the 14th Amendment has been stretched, and the example that comes to mind is Lochner versus New York, right? You had the case of Lochner in the turn of the 20th century, in which the justices argued that there was an unwritten freedom to contract principle in the due process clause of the 14th Amendment, the first sort of an example of substantive due process, in which they said that the state of New York wasn't allowed to adopt certain labor laws to protect bakers from unjust treatment by their employers and abusive and exploitative treatment by their employers. And the court struck down the New York law on the ground that it violated this unspoken, unenumerated, unwritten principle. And that was a case of where the justices smuggled in their own policy preferences under the auspices of interpreting the procedural language. And Justice Holmes had a stirring dissent, which later became embraced as the law. And I think a very similar thing is true of Roe v. Wade and Planned Parenthood versus Casey. I think it's an example of substantive due process gone awry. And again, I think the best way to be faithful to what a constitution is, what a judge is, and for that matter, to resist the temptation to do politics under the false premises of interpreting the law is to interpret the Constitution in light of its original understanding.
Here's an interesting question. How do you read the signs in our culture regarding any pushback against expressive individualism? I think that's a great question. I think of it myself, like our culture is so steeped in that mindset. You know, I Did It My Way by Frank Sinatra. I Gotta Be Me by Sammy. You just think the culture is awash in expressive individualism. Yes. So realistically, how can we begin to push back against that? I think your book is one effort, maybe.
Yeah, well, thanks. I mean, I think becoming parents is the best thing that you can do, or it may not caring for someone. You don't have to be a parent, but like you can. I mean, not everybody's a parent. You can care for someone in a self-sacrificing way and realize deep things about your own limits and your own vulnerability and others' vulnerability, and reflecting and trying to cultivate your moral imagination. And I have to say, I think the way that, and I think you can't really live as an expressive individualist. You can't really do it. I mean, we're so connected to each other. We're so dependent upon one another. And to live the incomplete and truth, which is ultimately a falsehood about who we are in that way, you end up with this kind of alienation, this dislocation, this yearning for belonging, and you fill it with things that sort of paradoxically result in kind of tribal behavior. I think identity politics is part of that. I mean, but the trick, I think, to changing the culture is not so much through, although it's important, making arguments and publishing books and so on, but actually through modeling the radical self-giving of people like Mother Teresa. The radical self-giving, the pouring out to oneself to others, to care for people without expecting anything in return. And in the context of disagreement, because people disagree strongly about these things, is you love the person first before you try to persuade them. And it doesn't, and that especially includes people we disagree with or people that we don't like, right? The idea that this is a person that you have to extend unconditional love and care to. And that's something, first of all, it's the right thing to do. But second of all, that kind of countercultural witness, I think, creates a shock to the system. I don't think people are ready for that. And when they see that, I think their heart softens. And I think then they're in a position to hear what we're saying and to listen. I mean, Mother Teresa didn't ask people what they believe before she cared for them in the slums of Calcutta. You know, when the Catholic Church invented the hospital, we didn't ask people what they believe before we treated them, right? You feed people, you take care of them, and when you do that, there's something that happens, and people see through these deeds, as well as supported by words and arguments, what it means to be human in the fullest sense, it seems to me.
Here's a great comment. You might be interested in this. When we first started our lecture series back in 1990, our second lecture was given by Dr. Edmund Pellegrino,
Oh,
the
wow.
director of Georgetown's Kennedy Institute of Ethics and the founding director of the Center for Clinical Bioethics.
Yes.
So I don't know if you ever had a chance to meet Dr.
Ed Pellegrino was one of my dearest friends and mentors, and Ed Pellegrino and I would travel to Strasbourg together twice a year, where we served as the co-permanent observers to for the U.S. government to the Council of Europe Steering Committee on Bioethics. Ed Pellegrino took over for Leon Kass after Leon stepped down from the President's Council on Bioethics, and I owe nearly everything to Ed Pellegrino. And the idea that that he was the first, or that he was an early speaker, is very moving to me, because there's no bigger giant in American bioethics than Ed Pellegrino.
Yeah, that's fantastic. Well, thank you, Dick Kirk. He's our historian for our society. He was the one who remember that one.
Yeah.
Yeah, you know, the one issue we haven't really touched on is getting to the end of life decisions. And I just had a personal experience a couple months ago when I was asked to sign a will with one of these advanced directives. Mm-hmm. And even though I'm a lawyer, my eyes just glazed over at this 15-page single-space document with every kind of permutation. And I just was sitting there at the signing table, and I just decided I can't sign this. I mean, so many of them, I thought, well, it depends. Well, I don't know, you know. And as I read your book, if I read you correctly, you were saying this is sort of an artificial kind of expression of this expressive individualism, that we're all supposed to know what we're going to think 20 years from now when we're, you know, disabled, and my autonomy is king. It's kind of it struck me as false. Number one, it's throwing a lot of stuff at people that they really can't get their heads around that easily. Not even to mention that, am I going to feel the same way 20 years from now as I feel now, or am I going to understand more things about my own life and the value it might have? But if I read you correctly, I think you were suggesting an alternative to that kind of approach to end-of-life decisions is more along the lines of the proxy, where you identify someone you trust, who knows you, who knows your values, and that has that kind of sense of community, that we're not in this alone, and there's someone that I trust that can make those tough calls when I'm not able to do it myself. I don't know, maybe if you could just address
Yeah, no, that's exactly right. I mean, the issue is, so in the context of end-of-life decision-making, the American push to resolve all questions, and I focus especially on people who are no longer able to participate in their own medical decision-making, right? A person who loses competence as a result of illness, injury, or age, and they're now trying to govern their own treatment decisions from beyond competence, using only a kind of legal document that memorializes what their preferences are, and that to me reflects a kind of false anthropology, as you were just saying. It assumes that the person who has lost their competence to make medical decisions for themselves, their need and their desire is the same as a person who is functioning at the height of their cognitive abilities. And really what we want to do is help this person assert their unencumbered self and exercise self-governance in this way. And that's not a fair description of the lived reality of that kind of dependence. Anybody who's been sick at all and dependent knows that when you go to the doctor, you're not going there to assert your unencumbered will. You're going there because you want someone to take care of you. And social science evidence backs this up. And it also shows that most people, lawyers and others, don't understand living wills. Most people don't have these advanced directives. And if they do, they don't actually accurately reflect their changed preferences over time. And so the aspiration to govern ourselves with a pre-commitment in a document illustrates a kind of false understanding about the lived reality of the dependence of that situation. And so, of course, our prior wishes matter, and it's good to write them down, and it's good to think about that, and it's good for decision makers to take those into account. But ultimately, what you want in that situation, because of your dependence as a function of your embodiment, is someone to take care of you, someone to make decisions for you that are in your best interests in light of, as they judge them in light of what they know about you and maybe what you said about yourself, but also based on the fact that they're seeking your good, right? They're trying to treat the patient that you are in the moment, not some idealized version of yourself. They're not doing things in hopes of, with a different kind of phase of life in mind. They're treating you as you are in the moment. And so I argued, along with what we argued in the President's Council on Bioethics, that the best model for that kind of decision-making is proxy decision-making, medical power of attorney, where a person, a live person, preferably one who knows you and loves you, is trying to act on your behalf in light of your preferences and values and so on, but not simply trying to govern our treatment by remote control with a document, with a sort of cold document itself.
Yeah. Well, just one more question. I think,
Okay.
I just am so impressed about the way you can take an issue that's such a hot button issue and people feel so strongly, particularly with abortion, and just address it in your book in such a charitable way. And I just wonder, kind of like, what's your secret? Because it's easy to get intimidated and to step out of the conversation because, in our environment, things tend to be so one way that you're, concerned about being canceled or whatever.
Sure.
If you speak up. And I just wonder if you would have any advice on how to participate in the public conversation in these issues, without falling prey either to joining in the nastiness on one end and then just kind of hiding and just kind of
right, avoiding it. Yeah, no, I think that I think you have to remind yourself that, especially as Catholics, we are called to love our neighbor, right? And that includes people that we don't agree with. And as I say, people that really irritate us and people who we think are deeply misguided, or even people that we think are doing wicked things. Like, we have to love these folks. And part of loving someone, and part is being honest and not trying to manipulate them, but to understand their perspective, to understand their argument, and be able to frame it in a way that they recognize and affirm as their own argument. Otherwise, we're playing a game. Otherwise, we're scoring debaters' points. But if you really want to make the case to for a particular proposition, you have to really inhabit the person you disagree with and their perspective, and try to respect it enough to articulate it in its strongest form, and then mount your kind of strongest response to it, and again, in a loving and charitable way. And A, it's the right thing to do, but B, you're not going to convince people who disagree strongly with you by attacking them or being disrespectful or mischaracterizing what they're saying or trying to take advantage of infelicitous formulations. Or, you see this a lot. In online discussions, not even discussion, just kind of vicious interactions, you see people mischaracterizing. You want to interpret what a person, the person who did this better than anybody I know is Dr. Leon Cass of the President's Council on Bioethics. He was, and Ed Pellegrino too, for that matter. But the idea is that we, as the staff on the President's Council, we were required to take all the arguments that were on the table, because we were advising a principal. We weren't the decision maker. The President of the United States was. And so we owed the President every argument on the question in its very strongest form. And what we had to do as a staff sometimes is take arguments we didn't agree with. Our opinion didn't matter because we were the staff, but opinions that we didn't agree with, and make them as strong as they possibly could be, so that when the President and other decision makers reviewed the arguments, they were able to make an informed decision.
That's great. Gosh. Well, one more question just came in.
Okay.
Dangerous to say my last question.
Okay, last question. This is the real last question.
This is the real last question. Okay. The fruits of laws and court decisions can normally be seen years after they are executed. Is there no internal mechanism for review and overturning clearly flawed laws and decisions? 62 million abortions seems to be screaming for such an internal check in our system of laws. I'm not sure.
So, okay, there has to be a case, in American law, there has to be a case or controversy to revisit a prior precedent. But there may be a deeper kind of question here, which is to say, why does the Supreme Court get to decide the question of the contours of the moral and legal community. Why can't the political branches of government make these decisions? Does the Constitution really empower the court solely to be the arbiter of this fundamental question with such high consequences and such high stakes? And that's a very deep question about the structure of the Constitution and the meaning and the relation of the political branches and the co-equal branches of government and federalism. And it's a very hard question. And I don't know the answer to it, but I mean, there are folks who argue that that in fact, at the very beginning, kind of giving the authority to the Supreme Court to make these questions, what was described in the Federalist Papers as the least dangerous branch, putting them in a counter-majoritarian position to make these kinds of policies might have been a structural error at the very outset. And it's something that would be interesting to explore. It's not my area of expertise, but I think it's an interesting question.
Great. Well, thank you, Professor. This has been really wonderful. I think the questions were all super that people sent in. And if it's okay, we'd like to put your PowerPoint on our
please.
website. And,
absolutely, no problem at all. And if folks haven't done it already, go out and grab a copy of the book. It's available online, Amazon. And please come to our website, ethicscenter.nd.edu, to see what we're doing at the De Nicola Center for Ethics and Culture, which aims to share the richness of the moral and intellectual tradition of the Catholic Church. We have a wonderful student fellowship program, 300 undergraduate and graduate students, and the Soren Fellows program, named for Father Soren, our founder. We're the principal engine of Notre Dame's pro-life and culture of life initiatives. We have obviously robust academic programming and publications. And finally, we assist the university in hiring and recruiting and retaining the most elite faculty in the world who share our passion for Notre Dame's Catholic mission. Yeah. So thank you, Matt. And thank you, everybody. I hope to see you in South Bend sometime, or maybe in Delaware. I'll be in Lewis in a couple weeks.
Okay.
Okay, you guys take care. Thank you so much. Good night.